These three are okay. Just asking you this information.
You folks all ready?
Yes.
Thank you.
All rise. Circuit Court is back in session.
Thank you. I'll be seated. Okay, so from now on, we'll just have to have lunch a little bit later than an hour because sometimes some of the restaurants are crowded sometimes at lunch. All right. So, Mr. Berlin, are you ready to go to the next motion?
Yes, Your Honor. Which motion would you like to do next?
About motion to compel plaintiff to produce documents.
That'd be Mr. Berry, but we're ready to go.
Mr. Berry.
Yes, Your Honor.
Your Honor, just in looking through my notes over the lunch break, I realized we may run into the same issues that we had because this is under seal as well as before. A lot of this material is covered in our brief, which is entirely under seal. I've looked to their brief, which you have unsealed portions of, to try and assess what I can speak to publicly. And I'll try and do it in such a way to be able to make the argument completely public and allude to things otherwise we're not. And then if necessary, approach the bench with Mr. Turkel, Mr. Harder, or Mr. Bennett, whoever's arguing. The unredacted FBI records that we received at the end of November and the beginning of December show that there were severe discovery deficiencies in this case. Some of them were alluded to during the argument on the fraud in the court. Others were not. And they basically will fall into three categories. And the motion is broken down this way, and I'll talk about them this way. First, the failure to produce documents to us. The second, the waiver of a so-called settlement privilege. And then the third is the waiver of the attorney-client privilege. Each of these issues raises other issues that we've talked about in our briefs. Some of them are misrepresentations. Some of them deal with spoliation. Whatever the reasons is, whatever issues come out, the bottom line is those documents should be produced at this point, or an explanation should be provided as to what happened to those documents. I'll first talk about the failure to produce documents to Gawker. And within this, there's two categories of documents that the FBI produced that suggest discovery deficiencies. And the first is materials that were provided to the FBI, but that were not provided to Gawker. And the second deals with materials that are disclosed to the FBI that suggest that there's additional documents that should have been provided. The problem with all of this is we don't know what we don't have. We don't know what's been given to us. We don't know what's been discarded, what's been preserved. But they suggest that there's more here. If documents do not exist, as I mentioned, there has been spoliation of evidence. And I'll talk about these two categories of documents. The first is examples of documents that were provided to the FBI. And here's where we kind of get into some of this confidential stuff. But in plaintiff's brief, that in the unredacted portion, the portion that you said could be publicly disclosed, there's an allusion to Mr. Houston having email communications with Nick Ritchie of The Dirty. The Dirty is the website that posted still shots of the sex tape back in April 2012, several months before Gawker posted its video excerpts. These email exchanges took place long after that, at the point after Gawker posted the excerpts from the sex tapes. The information that's seen in Exhibit 2 to our motion to compel and Exhibit 5 to our motion to compel are some of those emails between the two of them. Interestingly, the FBI redacted the names of the people in there, the person in there who was doing the emailing, but now, for the first time in their opposition, yesterday we found out that it was Nick Ritchie. Those email communications provide information that we did not know about, that were communications between Mr. Houston and Mr. Ritchie, both through the email and it appears through other avenues, perhaps through conversation, that were never disclosed to us. Now, plaintiff's opposition says, first, they admit that the person in those emails is Nick Ritchie, which is news to us. The second is that they claim that we've known Mr. Ritchie's identity for years, which is true. He runs the website The Dirty that posted the thing in April 2012. But we didn't know that he had had contact with Mr. Houston after April of 2012. And we didn't know the facts of those communications when we deposed Mr. Balea, and certainly when we deposed Mr. Houston. And he neither mentioned that. The evidence of those documents, and in particular, there's one phrase from Exhibit 2 that I'd point you to, that I'd like to mention, if I could, up at the bench. May I approach?
Please argument for the plaintiff. Mr. Hogan?
Yes, Your
We object to this not being open, but under the circumstances, one make our argument. There's other email communications between Mr. Houston and the government, whether FBI agents, people in the U.S. Attorney's Office, that were in the production from the FBI that were not in either Mr. Houston's or Mr. Balea's productions that should have been provided to us. Some of them were alluded to in the Florida Court motion. I'm not going to replow that ground, but certain of those things dealt with trying to obstruct the FOIA request, which Mr. Berlin had alluded to earlier. These documents clearly should have been provided to us. They were responsive to discovery requests served from the beginning of the case on Mr. Balea and a separate subpoena that had been served on Mr. Houston. There are also examples of documents, as I said, that suggest that other information and other documents exist that were not provided to us. In our brief, we mentioned a couple examples. There's FBI 302s. There's email communications from Mr. Houston to the FBI that refer to, just by way of an example, a media personality whose name has come up continuously throughout the case. In one of those communications, Mr. Houston described that person, who is unknown, as a good source of information. Now, plaintiff doesn't deny that these communications existed in their opposition. Plaintiff says, well, at Mr. Houston's deposition, you never asked him that question. Well, there's a couple issues with that response. First, we didn't know about the later communications that they were having with this person. Nobody disclosed this person as someone who had knowledge of the case from the outset. And we just learned two key facts. First, that Mr. Houston described this person as someone who was a good source of information. And then this person subsequently admitted publicly, after the news broke about the racist statements, that he had seen the tape, that it contained those racist statements. So again, we believe that this information and the timing that it was being conveyed is critical to what Mr. Balea was distressed about. And it's circumstantial evidence here as to damages, which we've talked about, and as to what was causing this distress, and as to what was the value of the tape. Mr. Balea, Mr. Houston only acted after this person was a good source of information. They only filed this lawsuit at that point. These are just examples. None of these communications were given to us. Nothing was given with respect to Mr. Ritchie after April 2012. As I said from the outset, we don't know what else is out there. We don't know why these things weren't provided to us. And there's really just no way to know. But it does raise questions about spoliation of evidence. All of this material existed at the time that Mr. Balea filed his lawsuit against Gawker and filed his separate lawsuit against the Clems. At that point, he and Mr. Houston both had an obligation to preserve evidence. There have been other instances where we have phone records from Mr. Balea that show text communications with people, including this media personality that I mentioned, as well as his publicist, that were not produced to us. We have the phone record showing the communications exist, but we don't have those communications. These FBI documents suggest that there's more out there, or was when they first filed this lawsuit. There needs to be some explanation. The documents that they have should be given to us, and there needs to be some explanation of why things that aren't given to us don't exist now, what happened to them, and why they weren't provided when they were first requested when discoveries began in this case. At bottom, there should be a very clear order to produce all communications or documents referring to communications concerning Gawker, the sex tapes, the Clems, and the FBI investigation. That we would like Your Honor to grant. The second issue that we raise is this waiver of a settlement privilege. Before I became involved in this litigation, there was a motion to compel settlement communications that Gawker filed as to communications relating to Mr. Balea and Mr. Clem. And there was a litigated issue at that point in the case. Mr. Balea took the position that there were communications, but that they were protected by a settlement communication privilege. We disagreed. The court sided with Mr. Balea, denied our motion to compel. We don't think that Florida recognizes such a privilege. I'm not going to argue that here. The issue here is that if this privilege does exist, as they've argued, and as has already been ruled, then that privilege has been waived. Mr. Balea never told Gawker and never told this court that there had been discussions or disclosures with third parties about those settlement communications. Their opposition, to be honest, I was stunned when I read it because they dealt with this in a paragraph. They concede that there were discussions about the settlement negotiations with Bubba Clem, with the FBI, and with Mr. Davidson. We point to specific documents in the FBI where that show this, and I would go so far to say they even logged one of those communications on a privilege log at the time that there was this motion to compel being argued. They also concede that they discussed the settlement negotiations with Heather Clem, with both the FBI and Mr. Davidson. The law in this is clear, and Mr. Balea doesn't contest it in his opposition. Disclosure of privileged communications is a waiver. It's just a black letter principle. As the 4th DCA said in the Hamilton case, it's black letter law that once the privilege is waived and the horse is out of the barn, it cannot be reinvoked. There's no exceptions to that rule, even when disclosure is to law enforcement. And the courts have been clear that this waiver extends to all communications on the subject matter. We cited cases in our brief, although it's under seal. The evidence that was obtained through the FBI is relevant to our argument that we had prior to the original trial date at the motion in limine hearing, that the settlement with Mr. Clem is a sham. It violated the rules of professional conduct, and we believe that it's pertinent to many issues at this trial and that pending motion. That motion is also under seal, and we explained part of this in our brief. I'd like to make a little bit more of a discussion, if I could, at this point.
This kind of topic that can be discussed publicly. We just talked about.
Okay. The topics.
Conflicting stories.
Right. So I guess the bottom line is that we had said in our motion in limine in opposition to their motion in limine actually on the settlement communications, the settlement agreement with Bubba Clem, and I think we're going to go down the same road with Heather Clem, is that settlement and the discussions with Ms. Clem, we believe, will be the same, are designed to be a sham to influence their testimony, and the things that Mr. Clem testified to in this case, in the public portions that are already out there in the deposition testimony, differs materially from what was told to the FBI, and we believe that the reason that was done was because of the way that the settlement was structured between he and Mr. Balea. We believe also that during the same time period that the FBI investigation was going on, and Mr. Balea's counsel and he were disclosing their communications with Ms. Clem and with her counsel. What those discussions would show is that they were seeking to do the same exact thing to influence her testimony in this case, and that the product of it is that the three of their testimony, as Mr. Turkel pointed out earlier, is consistent about what Mr. Balea did or didn't know and who knew what. In this case, what was told to the FBI and what is in the FBI documents shows that that is not true. They have different stories, there's different versions of events, and we believe that these settlement communications would show that. They conceded there was a waiver, they conceded the law on waiver. The only argument that they made in their opposition was that we seek communications to show knowledge of the filming. And as I just said, part of that is true. But we also think that it will show why Mr. Hogan was distressed, is the timing of the settlement with Mr. Clem was awfully suspicious. We don't need to go down this road entirely, but on October 17th, he was interviewed on the Howard Stern show, and Mr. Stern asked him about the N-word, and Mr. Clem's response was, he said it. The timing of the settlement, as we've outlined in our papers, portions of which are under seal, suggests that the settlement was prompted shortly after that statement was made. What we would ask Your Honor to do is to enter an order that the plaintiff produce all of his settlement communications, all of his lawyer's settlement communications with Mr. Clem and his lawyers. We also would ask for an order for him to produce all settlement communications with Ms. Clem and her lawyers. We would think that there was waiver throughout the entire time, and we would ask for an order stating that. The third point is with respect to the attorney-client privilege. With this, what you sealed in their papers suggests that the substance of a lot of what I would say is under seal. But there's two basic points. One is that there was an explicit waiver of the privilege. That is reflected in the FBI documents in an FBI 302, which is in Exhibit 22 to our motion, and in the handwritten notes of an FBI agent, Jason Shern, that's Exhibit 1. Both of those things show that the privilege was expressly waived. More to the point, as Mr. Houston has said publicly, and as plaintiff has said publicly, Mr. Houston, his lawyer, cooperated personally throughout the course of that FBI investigation. Had Mr. Davidson been prosecuted, Mr. Houston would have been the key witness. Once a lawyer goes down that road, the privilege is waived. Mr. Balea argues that the privilege is only potentially lost. Some of this is now under seal. What I will say publicly is that Mr. Houston and Mr. Balea shared a whole lot of information with the FBI and with Mr. Davidson that they have invoked the privilege on successfully in this case. I'll just talk about a couple topics. What they knew about the sex tapes, when they knew about them, their dealings with Mr. Davidson, the strategy in dealing with the Clems, as I just talked about, their strategy in dealing with third-party media entities like Mr. Ritchie, who we just mentioned, and this other media personality, and their strategy in litigating against Gawker. As I say, Mr. Balea has argued in this case that the privilege covers those topics. Incredibly, in his papers in opposition to this motion, he says that the privilege does not cover facts. But at the deposition that Mr. Berlin talked about earlier, those precise facts were the things that he invoked the privilege on and that Judge Case would not allow questioning on. Why he settled with Bubba Clem, what he did to find out about the dissemination of tape, why he didn't sue Mr. Ritchie, why he didn't sue the Dirty, why he didn't sue TMZ, whether he got sex tape offers for the sex tape, the subject matter of his complaint for law enforcement, how he learned about Davidson's allegations of additional tapes and the statements on those tapes. All of those things were deemed to be privileged. He should be stopped from arguing otherwise now. Those were things that he's already argued, that the court has already accepted, and that we've already been foreclosed from the information. He shouldn't be able to come back now and say, oh, the privilege didn't know, it doesn't apply to facts. We've been barred from getting answers to those questions. Mr. Balea and Mr. Houston disclosed their communications on these and many other topics to the FBI. As an example, if I may approach for just a moment. Actually, I'll come up in a second. I'll just group the rest of this together. The law on waiver and cooperation with government investigation is clear. Once you go down the road, a lawyer goes down the road of cooperating as a witness with the government and agrees to a potential waiver, it's a waiver as to all communications on the same subject matter. We talked about that with respect to settlement communications. We cite numerous cases in our papers that say that a lawyer's cooperation in a criminal investigation waives the privilege in other proceedings. There's no answer in their papers about that. Moreover, in this case, Mr. Balea has identified David Houston as a witness. Presumably, he will be sitting up in the chair here and will testify about the sex tapes, testify about what he did to try and stop their release, to stop Gawker from publishing, and why he was doing that. An attorney's agreement to cooperate as a witness is a waiver. If he's going to testify about actions he took and why he took them, that waives the privilege. He cannot invoke his actions as a sword and use the privilege as a shield as to why he was acting. Plaintiff argues that these communications with Keith Davidson were just an act, that it was all fake. Many of the statements that were made to Mr. Davidson, though, were the same kind of statements that were made in this case. Some of them are different, and we should be able to ask them and find out which are true and which are fake.
I think that was referring to the sting operation.
Right, where there was numerous communications between Mr. Balea and Mr. Houston about things that they had discussed before. And this would be the other part that I would come up to talk to Your Honor about.
Is now the time?
This would be great. That would be great. The last thing I would say is that the plaintiff argues that the crime fraud exception does not apply, and I won't go down this road too far because it's already been discussed. But there is no. Well, they say that there's no evidence that Mr. Balea sought advice of counsel to procure a fraud. It's hard to say because that's what would be in the communications. But we do know that when David Houston testified, that testimony was wholly inaccurate. And he sat at Mr. Balea's deposition while Mr. Balea said things that were wholly inaccurate. That is a crime. That is a violation. And that is what then leads to the crime fraud exception. It cannot be the rule that an attorney is permitted to commit a crime on behalf of his client, but the crime fraud exception does not apply. Unless you have any questions. Thank you.
I'll speak broadly about this first, but we started off today being accused of fraud on the court, and now from what I just heard, we can add to that list spoliation, severe discovery deficiencies, professional misconduct, and crimes. This whole process, all these motions sort of harken back to that old adage, that lawyer 101 adage, that when you have the facts, you pound the facts. When you have the law, you pound the law, and when you don't, you pound the table. This is pounding the table, and that's all it is. And it's distracting from the real issues that we need to be focused on as we're heading into trial. All of these motions are pounding on the table about discovery, about emails that have nothing to do with the issues that are going to be tried in this case, and they are completely collateral. They're speaking in generalities about the law. They're speaking in generalities about the facts. We're being accused of severe discovery deficiencies, and we're talking today initially about 5 emails out of the 3 years of litigation and thousands of documents. 5 emails that I'll go through in a minute. They don't explain to you at all, at any point today, why the content of the documents that they're complaining about is actually relevant to any of the issues that are going to be tried. And that's really the standard for any discovery that they're seeking to compel, is whether or not this is actually relevant to any of the issues that are going to be tried in this case. And they didn't explain it to you because it's not. These emails that are referenced with Nick Ritchie, they have them. They're complaining about spoliation, but they have these emails, Judge. And David Houston went back and searched and didn't find any additional ones. And these emails don't really relate to anything in this case. It's about other issues. It's about other potential tapes. It's about things that have no bearing on whether or not Mr. Balea knew at the time that he was recorded, whether he was recorded. And that's really the purpose of all of this discovery that they're seeking to compel. One of the statements that Mr. Berry said, Your Honor, was the first time that they found out about Mr. Ritchie in connection with these emails was yesterday. And when I heard that, I was thinking about the comments that Mr. Berlin made this morning about how important the truth is. Well, look at footnote 1 of their motion to compel, Your Honor. The man's name is right there. For them to say that they didn't know about him in connection with these emails till yesterday, and they have his name in their own motion? Let's talk about the truth in that kind of a context. The emails with Mr. Ritchie, if they do anything, Judge, they help our case. We pointed this out in our papers, but if you look at the actual content of what those emails discuss, they help us. They support us. So there's no reason why they would be purposely withheld or excluded as part of this conspiracy theory that's been concocted that somehow Mr. Balea wants to hide and conceal evidence in this case. The 3 emails that they complain about with respect to the extortion investigation, one of them makes references to conversations I think you've already discussed that the name can be disclosed with Mike Walters. They've completely butchered the timeline of when those discussions were taking place. They completely mischaracterized David Houston's deposition testimony about when he had those conversations with Mr. Walters. And at the end of the day, the conversations that are at issue in those emails have absolutely nothing to do with the issues that we're going to try. They're trying to make mountains out of molehills that have absolutely nothing to do with this case. The other two emails, quite frankly, clearly have nothing to do with this case. The only reason that they cite those is to try and make Mr. Houston look bad in front of the court. The settlement communications with Mr. Clem. They forget to bring up a lot of important facts in all the arguments that they're making today. A big fact they neglected to bring up in connection with this is that they have the actual settlement agreement itself. They already have that. They've had it for a long time. In fact, they've had it for so long that they were able to ask Mr. Clem about it extensively in his deposition, and they were able to ask Mr. Bolea about it in his deposition. They conducted discovery about it. All of these theories that they have as to why the settlement agreement is important, why the settlement agreement is relevant, why it's related to whether or not Mr. Clem's story changed, they have the agreement already. They don't need the communications, and they've asked him about it. And, Your Honor, in our response, I think it's really important. From pages 5 to 7, we cite chapter and verse Mr. Clem's deposition testimony about this very issue. And they asked him, why did your story change? Why did you come out initially and say that Mr. Bolea knew about this? And he explains to them in detail, which probably wasn't very easy to do, but under oath, when he raised his hand and swore to tell the truth at the deposition, what he said was, I was covering my butt. I was lying when I went out and said initially that Mr. Bolea knew about it. Because I was scared, because I knew he was right, because I knew that I double-crossed my friend, because I taped him without him knowing, and I was trying to cover for myself. And none of that, what I said immediately after this came out, was true. They don't like that testimony. Much in the same way they don't like the testimony of the other witnesses who have confirmed that Mr. Bolea wasn't involved and he was secretly reporting. So rather than focus on the facts, which are bad to their case, now we're focusing on the discovery process itself and trying to relitigate prior rulings that you have made numerous times in this case. Those settlement agreements have no bearing whatsoever. The settlement communications have no bearing whatsoever on the issues that we're going to try and on the testimony that they already have. As to the waiver of the attorney-client privilege issue, Your Honor, if you look at the Exhibit 22 to their motion that Mr. Berry referenced, when they say that there's been supposedly an absolute and unequivocal waiver of attorney-client privilege, I'm going to mention one word in that document that we mentioned in our response, which is hugely important. And it says potential. That wasn't a word that I came up with and used as part of an argument. That document says it. Now, they prefer to reference you to the handwritten notes of the FBI agent involved, but look at that form, Exhibit 22, and it says potential, because it may not happen. And in fact, it did not happen. A privileged communication between a lawyer and a client is just that. It's a communication. And it's not just any communication. It is a communication for the purposes of rendering legal advice. They have failed to cite a single example in their moving papers where any communication between Mr. Houston and Mr. Bolea that was for the purpose of rendering legal advice was disclosed as part of the extortion investigation. Now, it doesn't surprise me that they want to get into privileged communications between Mr. Bolea and his lawyer. Not only Mr. Houston, they've also been so broad as to ask for communications with us as well, because they don't want to focus on the facts, because they don't like the facts. And they don't like the law, so they're going to keep pounding on the table as they have done all day here today. The bottom line is this, with respect to all of these issues. They're complaining about emails relating to Mr. Walters and Mr. Ritchie. They've known about them long before this lawsuit began. Those are the guys who came out initially and had reports in March and April of 2012. They asked about them in Mr. Bolea's deposition. They don't list those people as witnesses in this case. They didn't subpoena documents from those people in this case. They didn't even seek to depose them in this case. So I don't know how they can sit there with a straight face and say that these things are critically important to the case to the point where they're accusing us of misconduct when they don't even identify them as witnesses or seek to depose them. The emails are hearsay. Wherever you relay comments that those gentlemen may have made, and they never sought to get their testimony, despite the fact that they know from published reports from these men supposedly everything that they know about the tapes. So I don't think that holds water at all. I think at the end of the day, this is just more and more an example of not focusing on what we're here to do. And it's wasting time, very short time and resources, particularly on our side. And I know Mr. Boleyn said, well, we had 30 days to mull over these responses. These motions and the motion for confidentiality, they were filed December 22nd, right before the holiday. I personally participated in the responses. We started working on them about 10 days ago. And it took an extraordinary amount of time. And we did it on the heels of filing within the 30 days prior to that 3 answer briefs and appeals that have been filed over rulings that you've made. None of which are ultimately going to have to do with what we're going to try here in a little over a month and a half. That's what we want to do. Let's focus on what we're going to try.
So can you touch for a moment on your position on the motion to determine the confidentiality just of the pleading itself, not all the exhibits?
The motion, and I guess the easiest way to say this is the motion to compel has a number of references intermingled with our arguments like the motion for fraud on the court that we think have their interpretation of evidence, what they believe evidence shows. There's an entire section on what they claim to be the relevancy of a lot of these issues, which is filled with references and citations to information that is confidential and attorney's eyes only in this case. And it would be extraordinarily difficult, I believe, Your Honor, to go through there and parse out all of that confidential information. It may be possible. Quite frankly, in the past, I think even with the briefs that we filed in the second DCA, we would file redacted versions of those. It may be something counsel can do after today. But I think at the end of the day, what we've talked about here, the public has a general idea of what the arguments are, what the legal issues are.
See, since your response was a response to all of their motions, I've already redacted portions, but not all. So I think that I should also rule on portions of this one. I'm really not seeing, and I think being consistent with the other rulings, I'm not seeing anything in the motion itself that refers to anything that I've already redacted.
I think there are a few references, Your Honor, if I can have some time to look through it.
Well, I can look through it while
Thank you.
I know it's a little late.
The brief may be like, I'll be brief.
Just on the confidentiality point, I think as Your Honor probably knows, it's their burden. We were happy to have all of it see the light of day. We don't believe that any of it should be confidential. One theme...
Tapes and everything.
Right. But at least as to this, we don't believe that anything is. And they haven't pointed to anything in particular, so it's hard to argue otherwise. One theme has run through the comments that Mr. Turkel made earlier, that Mr. Vogt made now, and I suspect we'll probably hear again when the next motion is argued, is that a lot of this stuff doesn't relate to this case or the issues in this case. I'd like to put a pin in that and say that we'll come back to that at a later date and talk about what properly is relevant to this case and what's not. If you look, they've also talked about spin and the way that we've characterized facts. What I'd like to do at some point is to come in here, strip away all the spin, and just go through the facts day by day by day with Your Honor and show how this relates to this case. But that's for a different day.
I don't know that we'll ever get to that day.
Well, we will with
Very few days left before the trial starts. So.
with respect to motions in limine and the admissibility of the actual documents, I think that we'll need to go through that exercise.
I don't know. I don't know that we have any time scheduled for just motions and limine, because I think I already ruled on most of them. I think we have one day on some other preliminary stuff, but I don't plan on revisiting a whole bunch of the motions and limine I already did.
Understood, Your Honor. This is all relating to new material.
You and the United States.
What? Right, exactly. One of the last things that Mr. Vogt said is that we didn't identify Mr. Walters, Mr. Ritchie, some of these other folks as witnesses in this case. That may be true to some extent. Whether those fellows come in or not, we're entitled to the plaintiff and his counsel's communications with those guys, which is what's at issue. And we're certainly allowed to cross-examine the plaintiff and his counsel about those communications with those guys. And that's what we're looking to do here. Right now, we didn't even know about the communications. We'd like access to them so that we can go down that road.
Well, I guess at this point in time, could you respond to Mr. Vogt? He said it in his response and just now. But you already have it. You have these emails.
We have the couple of emails with respect to Mr. Ritchie, and we don't have unredacted versions because we've only got the FBI's redacted versions. And Mr. Vogt pointed out footnote 1 in our brief, which is we're currently under seal. But what we said there is, based on what we can gather, we think this is Mr. Ritchie, based on what's out there. Until yesterday, we didn't know that for sure. We do have those emails. We don't have communications with anything with Mr. Walters. And it may be that the answer is there are none. But going back to the statement about their facts are not privileged, if David Houston has file memos, notes that recount the facts of those conversations, according to their argument, those things ought to be discoverable. With respect to Mr. Balea, more generally, his phone records show communications with Mike Walters, with other people that we do not have access to. We've previously litigated this issue to some degree. They don't exist. As it started with, we don't know what's out there. Could be other people. We just don't know, and what we don't know we can't argue about, and that's the problem. These couple things, evidence that there's other material out there, there was as of October 4th, and as of October 15th, as of October 18th, but they know in 2012, but if they don't exist anymore, somebody has some explaining to do. The second point that I was going to mention is with respect to the settlement agreement. Mr. Vogt mentions that we have the settlement agreement itself. That's great. But we don't have the communications relating to how that agreement got built and why it was built the way that it was. We would like to use those communications first for discovery purposes, which is all we're looking for at this point, but then possible impeachment. They pointed to Bubba Clem's testimony under oath here, but as I said to you in the closed portion that you subsequently said, I could say openly, after the settlement was entered, Mr. Clem said something materially different to the FBI, and then came in when Mr. Balea was at the table with him and said what Mr. Balea is now pointing to and said that that's Bubba Clem's gospel. Well, either Mr. Clem was lying in his deposition or he was lying with the FBI. Either way, this is all impeachment. We need to find out why, and we believe the settlement communications would be relevant. Finally, with respect to attorney-client privilege, Mr. Vogt said to you in the closed session, and he said it again in the open session, that we haven't pointed to any specific communications, and that's just not right. On page 12 of our motion, we cited examples within communications with, in this case, Mr. Davidson at Gawker 1484, 1486, 1492, 1511-13, 1521, 1537, 1574-75. There's also communications with respect to other people that they shared with the FBI at Exhibit 16, 17, 23, 30-33. All of that is on page 12. Our point, though, isn't just that they disclosed communications, these specific instances. It's a subject matter waiver. Once you go down the road of saying, I'm going to tell the FBI about these topics, once you go down the road of saying, I'm going to tell Keith Davidson about these topics, it's a subject matter waiver. I don't need to go through the 2,000 pages of FBI documents and point to every instance. It's a subject matter waiver, and that's never been contested. With respect to the word potentially, what that document from the FBI shows was that the agent told Mr. Houston, if you cooperate in this investigation, it will be potentially lost. And Mr. Houston agreed to cooperate. The law is clear that once an attorney goes down that road, it's a waiver. What the agent was saying, what that document says, is if you go down this road, it will be potentially lost. Mr. Houston went down that road, and that's why it's lost. And as it makes clear in those documents, it pertains to waiver in this suit, too. Thank you.
Have you had an opportunity to look through the motion?
I just wanted to run a couple of issues by Mr. Hart.
Why don't we just take an informal break?
Thank you.
A stretch break.
Thank you.